So good evening, everyone, and welcome to the book presentation, The Investor-State Dispute Settlement System, Reform, Replace, or Status Quo, edited by Alan Anderson and Ben Beaumont. This event is organized by the Washington Foreign Law Society. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote the knowledge and understanding of international legal matters, comparative legal issues, and foreign law. Given the number of participants, you would be muted during the webinar, but able to communicate with us and to the panelists via the Q&A section. Please send questions for our distinguished panelists using the Q&A section on your screen, and we'll get to your question toward the end of the presentation. This session will be recorded. Don't forget to follow us on Twitter and LinkedIn. I will put the link in a moment via the chat. One final note before I hand the floor to Alexandra, our board member of the Washington Foreign Law Society. She will introduce the panelists. Please consider becoming a member of the society. We have discount rate for students and for government employees, and we have a very accessible rate. I will put the link to the membership as well in the chat. And with this, I welcome Alexander. The floor is yours.
Thank you, Juliana. Good evening or good afternoon, everyone. It is my pleasure tonight to introduce you such distinguished panelists. Alan Anderson, who is one of the two editors of the book, along with Ben Beaumont. Alan specializes in dispute resolution, particularly international arbitration. He's a fellow of the Charter Institute of Arbitrators and of the Australian Centre for International Commercial Arbitration, as well as of the Asian Institute of Alternative Dispute Resolution, where he's also an accredited international mediator. Alan has also participated in the work of UNCITRAL's working groups 2 and 3. Alan is the president of Alan Anderson Law Firm based in Minneapolis, Minnesota, US, and a door tenant with Littleton Chambers in London. Among the distinguished contributors of the book with us tonight is Kieran Gore, who is a longtime friend of the Washington Foreign Law Society. Kieran focuses her practice on US and transnational dispute resolution and specializes in complex litigation, international commercial and investment arbitration, and global arbitration. Kieran currently practices as counsel in the law offices of Charles A. Chump, PC, and also serves as an associate editor of the Kluwer Arbitration blog and the ICSID Review Foreign Investment Law Journal. Tonight with us is also Miriam Gahoon, who is joining us from Australia. This is a very international panel tonight. She's an associate in the New York office of Gibson, Dunn and Crutches LLP, where she's a member of the International Arbitration Practice Group. She specializes in international arbitration and public international law dispute. She is admitted to practice in New York and in Queensland, Australia. Last but not least is Brian Mcgarry, who is with us tonight. He's an assistant professor of public international law at the Wto Center for International Legal Studies Institute of Public Law at the Faculty of Law of Leiden University in the Netherlands. He's joining us from the Netherlands. And he's also a visiting professor at Sciences Po Paris. A member of the New York Bar, he has consulted with states and intergovernmental organizations on a range of legal matters involving international trade and investments. So, Alan, I'll leave the floor to you totally, but I'm still eager to hear, how did you get the idea for this book, and how did you manage to gather all these prominent contributors from all over the world?
Thank you, Alexandra, and welcome to everyone. We are coming to you from literally around the world. I think the presenters and everyone literally spans just about every single time zone. So thank you all for joining us. The book, excuse me, grew out of the fact that the organization that I am a part of, the Forum for International Conciliation and Arbitration, has observer status at UNCITRAL for all of its working groups. And one of the working groups that I personally have been attending for a number of years is Working Group 3. When Working Group 3 took on its current project to consider reforms to the investor-state dispute settlement system, right from the beginning, it was apparent that this was going to be a controversial topic. As I mentioned in the introduction to the book, on the very first day, well, it took the first day and a half just to select who would be the chair of the working group, which for any of you who had the opportunity to participate in working groups of UNCITRAL, selecting the chair usually is something that takes about 5 minutes. But we actually had to go to a secret ballot to select the chair. And out of that, my colleague, Ben Beaumont, and I thought, you know, this is a topic that it's clearly going to continue on for some time. It's clearly one that there are a lot of views, and we thought that we could come up with something to contribute to the ongoing debate. Indeed, I would say that at the most recent meeting of Working Group 3, which was done virtually, a plan was proposed that the work on this project will extend over the next 5 years. And we're asking UNCITRAL to give an additional $4 million budget to the group. We'll see how that goes. Anyway, so we were very fortunate to have 29 contributors, believe it or not, from literally around the world for 20 chapters in the book. And they span the globe, and they span the areas of expertise from practitioners to arbitrators to academics. And we have covered a great many of the ongoing topics. So the book, I think, hopefully will be a contribution to the ongoing debates. And certainly it was a lot of hard work and effort, not only as editors, but certainly all of our contributors. And you have 3 of our wonderful contributors here today to tell you something about their topics. First up is going to be Dr. Brian Mcgarry. He's going to be talking about enforcement of investment court decisions under the New York Convention and a search for defining elements. And then we'll hear from Kieran Gore. She's going to be talking about the replacement for NAFTA. We'll call it NAFTA 2.0, the US-Canadian-Mexico Act, now 1 year old, and what's going on there. And then rounding things out will be Miriam Kaloun, who will be talking about aspects of improving post-award efficiency and some of the proposed reforms to the ICSID annulment process. After that, we'll have hopefully a fair amount of time for questions and answers. So please submit your questions and answers through the chat function or Q&A. And with that, I'll turn it over to Brian.
Well, thank you, Alan, and thanks indeed to the Washington Foreign Law Society for your warm invitation and excellent organization. Glad tidings from The Hague to my fellow speakers, and I hope our audience is enjoying good health and fresh air. The closing chapter of the book approaches the question of enforcement of decisions rendered by a global investment court or similar model of investor-state dispute settlement. It illustrates findings from my broader work in comparative treaty interpretation and institutional reform, which I'll discuss for our audience's kind consideration. I'll be alluding to some historical research, so I'd like to acknowledge Elena Marashko, my co-author in a recent Kluwer arbitration blog post on this topic, for her valuable research assistance. I hope it's not too late in Moscow, Elena. In Vienna, the recently resumed 40th session of, as Alan said, Working Group 3 has not resolved the prospective institutional form of ISDS. Nonetheless, its current agenda raises questions concerning the enforcement of decisions made by any new institutional body. My brief intervention this evening focuses on the potential establishment of an investment court or appellate structure without the kind of self-contained enforcement regime found under the World Bank's ICSID Convention. In other words, a system in which the enforcement of this new mechanism's decisions is a matter left to domestic courts. Perhaps the most critical question this raises is whether such decisions would be regarded as arbitral awards, as required if the investor is to rely on the widely ratified 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. Now, of course, the defining elements of an arbitral award is not the only question an UNCITRAL delegate might raise upon glancing at the New York Convention. Asset state courts could also hear arguments as to whether the decisions of an investment court or appellate mechanism are foreign within the meaning of that treaty. But on this point, courts in many states have found that national decisions satisfy this requirement under Article 1 of the New York Convention. What about the question of court versus appellate structure? Might that have some bearing upon the arbitral character of the decision and thus the application of the New York Convention? No. The institutional form of a new investment court or appellate structure is irrelevant to the arbitral requirement of Article 1, Paragraph 2 of the New York Convention, which expressly covers awards rendered by permanent arbitral bodies. Others have questioned whether parties submit to an investment court through an agreement in writing, a requirement for enforcement under Article 2, Paragraph 1 of the Convention. An institutional body to which the parties do not directly consent, or which they may be legally required to use, differs from traditional depictions of arbitration as arising from an agreement made directly between disputing parties. Yet many international investment agreements confirm that arbitration without privity, the investor's acceptance by initiating proceedings of the host state's treaty-based offer to arbitrate, satisfies this requirement under the New York Convention. The US Second Circuit and the English Court of Appeal have recognized this as well in New York Convention enforcement proceedings. These findings are borne out in the practice of institutions as well, with structural similarities to a prospective global investment court. On the question of foreignness, Egyptian courts have characterized the Arab Investment Court, which is seated in Cairo, as, quote, not related to the national procedural systems, including any national arbitration system. In the specific context of New York Convention enforcement, the US Ninth Circuit has found that decisions of the Iran-US Claims Tribunal satisfy the requirement of an agreement in writing, while the English Court of Appeal questioned whether that tribunal's constitutive treaty met this threshold. It considered that the act of filing a claim in that forum cures any such shortcomings. So this left me wondering, of course, what exactly is this thing called an arbitral award? Beyond the requirements of an at least theoretical basis of consent, are there limits to the malleability of arbitration as a term, and thus to reliance on the New York Convention, which we ought to consider before laying the bricks of an investment court? In my view, this question does not arise for UNCITRAL delegates in a vacuum, despite the fact that they meet in hermetically sealed fortresses built on islands. In particular, the history and current revival of WTO arbitration in the form of the multi-party arbitration agreement, established last year after the WTO appellate body lost its quorum and in order to circumvent US obstruction, illustrates how parallel developments across international economic law clarify the scope of treaty references to the term arbitration in this field. During the Uruguay round of negotiations, which led to the creation of the WTO, several delegations proposed arbitration as an alternative to panel proceedings. Now, those proceedings under the GATT agreement had been fundamentally crippled by its own inherent vice, the right of a losing party to block the adoption of a panel report to avoid compliance. In the 1994 WTO Dispute Settlement Understanding, the newly established WTO provided for two distinct types of arbitration. One of these mechanisms concerns narrow questions regarding the implementation of WTO panel and appellate body reports, determining the reasonable period of time for compliance under Article 21(3)(c, or the appropriate level of suspension of trade concessions in response to non-compliance under Article 22.6. An alternative arbitration mechanism arises under Article 25, whereby parties can agree to efficiently bypass mainstream WTO proceedings. Delegations during the Uruguay round characterized these diverse types of arbitration principally in terms of their expeditious objective. During negotiations, the US had initially proposed arbitration, quote, as an alternative means of dispute settlement for defined classes of cases or by prior agreement of the disputing parties on an ad hoc basis, and where the arbitrator's decision would not require approval by the GATT Council. The discussions among delegations demonstrated uncertainty as to how arbitration was structurally distinguishable from the panel procedure that already existed, and thus as to its place within the GATT system. Beyond sharing an interest in rapidly resolving discretely defined issues, delegations thus deliberately avoided providing further detail regarding the character of arbitration. This explains the skeletal drafting of Article 25 of the Dispute Settlement Understanding, as well as states' consensus on, quote, the need for rapid completion of the dispute settlement process, including implementation under Articles 21 and 22. The other element of arbitration that can be inferred from its consideration and subsequent ratification by 164 WTO members is, as noted from the outset, a requirement of consent to a binding settlement. Both the implementation and alternative models of WTO arbitration I've cited result in binding decisions, and compliance with these decisions remains subject to WTO institutional oversight. While implementation arbitration is often described as sui generis, unilaterally instituted arbitration under Articles 21 or 22 is nonetheless consensual in light of members' treaty-based consent to the prospect of incidental proceedings arising during cases. By contrast, aspects of party autonomy often taken for granted in arbitration did not survive the Uruguay round. While the choice of arbitrators under Article 25 of the Dispute Settlement Understanding was left to the parties, Article 21 arbitrations leave this choice to the WTO Director General in practice, and Article 22 arbitrations are conducted by the originally constituted panel when available. This diversity notably departed from the recommendation of the GATT Secretariat, which suggested defining arbitration as, quote, the process of resolving disputes on the basis of respect for law through decisions binding upon the disputant parties by arbitrators appointed by the parties to hear a particular case submitted by the parties. WTO arbitration also provides no quarter to other common conceptions of party autonomy in arbitration. While Article 25 of the Dispute Settlement Understanding envisaged that members would be free to block the intervention of third parties in their arbitration, Articles 21 and 22 arbitrators have found an implied power to admit third-party participation in these proceedings. Each model also differs in terms of the requirement of party consent to the determination of arbitral procedures and the possibility for parties to mutually adjust the scope of issues addressed in the award. So, upon surveying this thing called arbitration in the WTO context, we are left to conclude that the states parties to that treaty system view the component elements of arbitration as consisting solely of consent and expediency. I believe it's worth recalling at this juncture that the WTO is a widely ratified dispute settlement system under international economic law. This gives rise to several rationales under the law of treaties for a judge or counsel to interpret a term similarly across contemporaneous treaties ratified by the same parties in regards to related subject matter. And this may include the New York Convention, among other instruments of post-Bretton Woods international economic integration. Looking back on my brief intervention, we can perhaps agree that by shifting to a more institutionalized ISDS model, states retain the universal requirement of parties' consent to a binding decision. Moreover, each of the forums I've mentioned serve the objective of providing more expeditious dispute resolution than available alternatives. ISDS proceedings would be expected to remain more efficient than domestic trials and appeals. And the various types of WTO arbitration are faster than default mechanisms under the Dispute Settlement Understanding or the endless negotiation of implementation. So while parties, for example, challenging the enforcement of the Iran-US tribunal decisions have never directly questioned investors' lack of control in selecting tribunal members, WTO arbitration illustrates, as I've shown, that states do not consider party autonomy in appointment and procedural matters to be sine qua non conditions for ascribing arbitral character to a mechanism or legal decision. So in conclusion, when viewed as a relevant context for treaty interpretation, the most widely ratified economic conventions reflect a continuum of understanding as to the core terms of international arbitration. Through this history, we see the arbitral character of an award does not arise from parties' choice of procedure or arbitrators. Rather, as the UNCITRAL Secretariat noted last year on the prospect of combining annulment and appellate structures, such complexity, quote, might run contrary to the objectives of finality and efficiency inherent in arbitration. Crossing the Alps between Vienna and Geneva, so to speak, these two elements should, in my view, continue to bind the 21st century reforms of 20th century economic dispute settlement. I thank you for your kind attention.
Thank you very much, Barry, for that very interesting presentation. And now we'll go to Karen to hear about NAFTA 2.0 and the year's worth of experience with the new US-Canada-Mexico trade agreement. Karen?
Thank you so much, Alan. It's first a pleasure to be here. It's a festive occasion because we're celebrating the launch of this book, so I'll congratulate both Alan and Ben again, but I'm also just really happy to be here with the Washington Foreign Law Society because as this event has been going on, I've been thinking about two of my most memorable pre-pandemic social interactions, and they both involve the Washington Foreign Law Society. The holiday party in December 2019, possibly the last holiday party ever, and it was so fun. And then also the gala where we honored Meg Kinnear. So it's just really nice to be back with you. I hope we can do this in person next time. So my book chapter, the one that I co-authored with Charles Camp, who many of you will know as a president emeritus of the Washington Foreign Law Society. So as Alexandra said, we're old friends and great friends, and we're happy to be here with you. Our chapter is titled The Rise of NAFTA 2.0, a case study in effective ISDS reform. And in that chapter, Charles and I try to address the core question, reform, replace, or status quo, by highlighting the North American regional experience with ISDS. So the chapter aims to be holistic. We start off by discussing the economic and political factors that gave rise to NAFTA in 1998, including its ISDS framework at chapter 11, and then also the experiential factors that led to the advent of its successor, which went into force 27 years later on July 1st, 2020. So that's the USMCA, the US-Mexico-Canada Agreement, or it might be the Canada-US-Mexico Agreement if you're in Canada, or it might be TMEC if you're in Mexico. So depending on what you call home and where your loyalties lie, it's a completely different agreement. Our chapter does not suggest that the North American experience presents the best example or the only blueprint for regional ISDS, but it's an important case study from a global perspective, perhaps because it carries a lot of experiential reality. NAFTA, the predecessor, was entered into in 1998. That was considered revolutionary for a couple of reasons I'll discuss briefly in a moment. And then it lived through a lot of experience and evolution. So I like to think, or I would like to propose, that the USMCA opens up ideas for other stakeholders at the ISDS crossroads to learn from that experience. So in December 2019, around the same time that we were having our great Washington Foreign Law Society holiday party, President Trump tweeted that the USMCA was the best and the most important trade deal ever made by the United States. This was separate from his repeated and frequent claim that NAFTA was the worst trade deal in history. So this is probably the one time I'll quote President Trump in this way. And I'd like to say we have nothing in common other than being both New Yorkers, but I definitely need more than 140 characters to characterize NAFTA and its successor. Its successor, USMCA, is a trade deal consisting of numerous chapters, annexes, side letters, and although it has a lot in common with its predecessor, NAFTA, it's actually also quite different. And what I'd like to highlight today is not so much how we got from point A to point B, but actually what's happened since point B. A lot has happened since USMCA went into effect, or went into force on July 1st of last year. Our book chapter was published some months later at the moment that we felt the USMCA was new and innovative. And now as we approach that first anniversary, there's been lots of developments. So I want to discuss those developments not only from an ISDS perspective, but also on the merits and successes of the trade deal, because those are other ways that you could assess its success. So ISDS not being the only factor that's relevant. So let's talk about economic impact first. In 2019, a US International Trade Commission report tried to determine how the USMCA, the forthcoming USMCA, would affect the US economy. And honestly, the figures weren't spectacular. And that's the word that's used on the USTR's website, that the USMCA is not spectacular or isn't spectacularly innovative or revolutionary. The USMCA was expected to raise real US GDP by $68.2 billion. That sounds like a very big number to all of us, but it's actually only 0.35% of the total GDP of the United States. In terms of employment, it was expected to generate 176,000 US jobs, or 0.12% of the overall number of US jobs. The biggest impact of the USMCA was expected to come from new rules on international data transfer and e-commerce. So this is a point where it's really important to realize that, well, NAFTA, no matter how good or bad it was in need of revolution and evolution, because data transfer and e-commerce were not relevant in 1998 in the same way that they are in the present day. So in that sense, the USMCA intellectual property rights provisions were expected to increase protection for firms in the US who rely on their IP rights to grow their businesses and have economic success. The agreement also restructured automobile production by increasing regional value content, requirements for more American parts and vehicles. So 40% of each vehicle was supposed to be made by workers who were making $16 per hour under this latest version of the agreement. Now, so those were the projected figures in late 2019. Two super important things have happened since. COVID-19 changed our entire global supply chain and our expectations for that global supply chain, and President Biden took office. So both these two factors have significantly impacted what's happened in the USMCA and also the anticipated goals for it. In general, the Biden administration has signaled that one of its priorities will be to strengthen diplomatic relations with America's traditional allies, including Canada and Mexico. And this is supposed to be in stark contrast to President Trump's America First ideology. And so this very early and visible commitment to strengthening economic relationships within the North American partnerships and trade partners was supposed to really prioritize the USMCA. But with COVID-19 still impacting the global economy, people say, or analysts are saying, that there's nothing in the USMCA that's actually going to help. It's not actually going to have any of those anticipated impacts that I just described from that 2019 report. A really salient example comes actually from Texas. So Mexico being Texas's biggest historic trading partner, we're seeing figures that in Texas ports, there's already a 50% decline of trade based on pandemic related disruptions. So that's a really staggering figure because we're in the first year of a brand new trade deal that's supposed to have positive impacts, but we're not looking at this in a vacuum and we're already seeing a decline in general. Now, if you were to switch focus to Mexico, the outlook isn't any simpler. So for those of you who are interested in energy reform, I told you I'd talk about lots of different factors and not just ISDS. For those of you interested in Mexican energy reform in particular, you'll be familiar that in 2013, Mexico adopted constitutional reforms to liberalize their energy industry, to put an end to state-run monopolies such as Pemex and the CFE, which oversees their electricity grid. And through those reforms, Mexico was supposed to open up its energy sector to allow privatized investments in all segments of oil and gas and energy. So that, in theory, would sit very well with the USMCA. And just to put a little footnote there, that energy and electricity are considered highly regulated industries under the USMCA, which get a slightly different approach for ISDS under that agreement. So given Mexico's prolific natural resources, these reforms were projected to receive $32 billion of foreign direct investments simply from the US and expected to obtain at least $25 billion more in coming years. So this is a key input for the USMCA. Now, what's really interesting is that the current president of Mexico, who entered into office in the end of 2018, so right around the time that the first draft text of the USMCA was released, he oversaw a policy shift, and the government control of Mexican energy industries was overhauled. It was completely reformed again, quoting sovereignty and national security concerns. It sounds very familiar because I think we hear things like that from former President Trump and some other recent executive level leaders in other nations. So the output of this is that just this past year, in December 2020, the Ministry of Energy of Mexico issued new hydrocarbon rules, which are changing the opportunities to achieve new permits within Mexico by both local and foreign suppliers. And on top of those rules, on May 4th of this year, so just about a month ago, the Mexican government passed an amendment sponsored by the president and approved by Congress to that Hydrocarbons Act that continued to modify key provisions. So that amendment grants state-owned entities a greater role in the mid and downstream sectors of oil and gas. Now, all of that is relevant to the USMCA simply because you have a lot of US foreign investment in Mexico. So what you're seeing already right now, although no USMCA claims to my knowledge have arisen yet, I don't think they could with respect to the timing that's currently in place and the exhaustion of local remedies requirements under the USMCA. What we're seeing are the beginning seeds of possible claims from US investors against Mexico for these reforms and the impacts of these reforms, and also the prioritization that's being given to the national industry. So what we already know for sure, not only with the oil and gas, but also with the electricity bill that's also pending in the Mexican legislators, that there have been over 30 different interventions filed by investors challenging the constitutionality of these various interventions and alleging that they violate constitutional rights, including free competition, the competitiveness of the power sector, environmental protection, so on and so forth. And that these judicial battles, these litigation proceedings are really going to be the seeds for USMCA claims in coming years, because there is that exhaustion of remedies requirement that you can read about in the book chapter that will require parties to first make their claims under Mexican law before they can allege violations of international obligations and protections under the USMCA. So I'm going to fast forward a little bit because I don't want to leave Canada out of this, and I only have a few more minutes to talk to you. So Canada, although it's left the ISDS Chapter 14, it was a member of Chapter 11 under NAFTA, but under Chapter 14, it's no longer a participant. And that is a really key change, a key shift from NAFTA to the USMCA, because NAFTA was always heralded, and Judge Charles Brower has written about this, US congressional liaisons who helped negotiate NAFTA have written about this. NAFTA was heralded for its equal treatment of the various states, the 3 state parties that were involved. That regardless of what their respective positioning may be, which at the time included obviously Canada and the US, 2 first world nations, there was equal treatment amongst them. The USMCA, reflecting evolution and change, is not the same thing. You don't have Canada at all participating in the ISDS framework. And so what that means is that there's no longer an equal and balanced approach. And it also means that US investors and Mexican investors, at least under the USMCA framework, cannot assert claims against Canada. Now, I'm going to add another footnote. I don't know if you're supposed to have footnotes in presentations, but I'm going to have a second footnote, which is that Canada and Mexico continue to participate in ISDS with each other under CETA, because they're both parties to CETA. So what we have that's very interesting here is that it's unclear where Canada strategically sits with respect to ISDS, because they have withdrawn fully from it in the USMCA context, but they remain committed to ISDS in principle in CETA, and also in the latest model FIPA that was released by Canada just a couple of weeks ago. That said, Canada is not outside this realm of disputes that are arising in this USMCA world. And so there is currently a USTR consultation pending with Canada that commenced in December with respect to the dairy industry. So this is something that started under the Trump administration. It's continuing now under the Biden administration, where there is an allegation by the US that Canada is illegally reserving a portion of certain quotas for certain types of dairy products and imposing tariffs and other things against US suppliers. So that's another dispute that is bubbling. It's more in the state to state realm and not coming up under Chapter 14, but it's still something to watch, because if we look at the USMCA holistically as a trade facilitation deal, as something that's intended to improve the North American environment, I think there's just a lot of factors bubbling up. So all that to say, that's the update from North America, the update from USMCA. And there's a lot to watch. And so if we continue to think about this ISDS reform, replace, or status quo question, I think at least from the North American perspective, within the first year of USMCA, we have a lot of questions as to whether these dispute resolution mechanisms, both in Chapter 14, but also in the separate state-to-state dispute resolution mechanism, are continuing to bubble up, and there's just a lot to watch. Thank you.
Thank you, Karen, for that interesting talk about the current state of affairs with USMCA. And now we will rapidly travel probably a little bit more than halfway around the world to Canberra, Australia, for Miriam. Take it away.
Thank you so much. I'd like to echo my co-panelists. Thank you to Ben and Alan and the Washington Foreign Law Society for hosting this event. As Alan noted, I'll be briefly discussing what happens in the ICSID system once an award has been rendered. And one of the key advantages that's often cited is that once awards are rendered, they are presumed to be binding and final without any right to an appeal. However, this statement doesn't take into account the post-award remedies provided for under the ICSID system. My co-author on this chapter and colleague Ankita Ritwik used this as an opportunity to first take stock of parties' use of post-award remedies to, in some cases, prolong and delay enforcement of adverse awards, and secondly, to suggest proposals to enhance post-award efficiency. So as many of you will be familiar, under the ICSID Convention, there are 5 post-award remedies that are available to parties following the issuance of an award. Under Article 49.2, a party may request that a tribunal provide a supplementary decision on any question that it is omitted to decide in the award within 45 days of rendering. This is often used by parties where a tribunal has omitted to decide a relatively minor point, and the additional reasoning can then just be transposed into the already rendered award without affecting core reasoning. Article 49.2 also permits parties to request a rectification of the award by asking the tribunal to rectify any clerical, arithmetical, or similar error in the award. This would include, for example, correcting arithmetical errors in the calculation of the quantum of damages. Under Article 50, parties can request an interpretation of the award if a dispute arises as to meaning or scope, and this requires the existence of a dispute as to the meaning of the operative section of an award. It also requires that the dispute is sufficiently concrete to be susceptible of a specific request for interpretation. Under Article 51, parties can request alteration of the award on the basis of previously unknown facts that may have the ability to decisively affect the award, but the new fact must have been unknown to the tribunal and the applicant party at the time that the award was rendered, and this lack of knowledge must not be attributable to negligence. Article 49.2 also permits parties to request rectification of the award by asking, under Article 51, parties can request, there we go. So finally, under Article 52, parties can seek annulment of an award on 5 narrow annulment grounds. The 3 most commonly invoked are that the tribunal has 1, manifestly exceeded its powers, 2, that the tribunal has seriously departed from a fundamental rule of procedure, and 3, that the award has failed to state the reasons on which it's based. Article 52 also permits annulment where the tribunal was not properly constituted or a member of the tribunal has committed corruption. Each of these grounds exists to safeguard against the occurrence of egregious procedural violations in the course of the underlying arbitration. However, when we looked at awards that were rendered between 2011 and 2020, we saw that annulment was sought in almost 40% of cases, with many parties attempting to treat annulment as an automatic right of appeal. Since 1971, though, ICSID awards have only been partially or fully annulled in 19 cases. So this means that about 5% of all ICSID awards rendered have been annulled, and it reaffirms that annulment is an exceptional remedy, with most ad hoc committees recognizing the limited scope of their review. However, this annulment process itself can also create serious delays that undermine the principle of finality of an award. Our analysis of ICSID annulment cases as of 2020 indicates that it takes an average of 773 days, or over 2 years, to resolve an annulment application. This is often punctuated by long delays in commencing annulment proceedings, with it taking 70 days on average to appoint an annulment committee. The swift constitution of the ad hoc committee becomes particularly important in cases where parties have requested a stay of enforcement. Article 52(5) of the ICSID Convention provides for an automatic stay until the ad hoc committee is constituted and can determine if the stay should be continued. Either party may request an expedited ruling on the stay, in which case the ad hoc committee must decide whether to continue the stay of enforcement within 30 days of its constitution. Our analysis, however, shows that in practice, the average number of days to resolve a stay application is 233 days. This is more than 7 months, despite the 30-day suggestion. Crucially, the ICSID Convention requires the ad hoc committee to be constituted before it can resolve any dispute over the stay. There are no emergency appointment procedures that would enable the stay to be removed pending ad hoc committee constitution. This not only prejudices an award recipient by delaying enforcement, but may also allow the party applying for a stay to engage in asset anticipation in an attempt to make themselves judgment-proof. In light of this, improving post-award efficiency needs to be a priority in considering reforms to the ICSID system. This will preserve the principle of finality, which makes the system so attractive to states and investors alike. And there are several ways that this could be done. First, steps could be taken to encourage utilization of post-award remedies other than annulment that may better address an applicant's grievances with the award. However, this does not address circumstances where often these proceedings themselves are also used as a delay tactic by a party dissatisfied with an award, who may nonetheless plan to eventually apply to annul the award in order to delay or prolong enforcement. Usage of post-award remedies also doesn't preclude a party from applying for a stay of enforcement. And we see this, for example, in the recently concluded case of Victor P. Casado and the Republic of Chile, where it took almost 22 years to obtain an award that was final and binding. The request for arbitration here was registered in 1998. And in addition to the original arbitration, the proceedings included 2 annulments with stay applications, a revision also with a stay application, a supplementary decision, a resubmission, an interpretation, and a rectification. So further clarity in the ICSID arbitration rules and developments in jurisprudence on post-award remedies beyond annulment may help to mitigate these concerns somewhat. In addition, unsuccessful applications of post-award remedies could be more strictly scrutinized by ad hoc committees, particularly if the applicant is using the annulment proceedings to re-argue grievances that have already been advanced in another post-award proceeding. Second, there's scope to further define deadlines in the ICSID arbitration rules within which the annulment process must operate. This could include deadlines for the constitution of the ad hoc committee, the first procedural session, and for issuing the decision on annulment. Given the urgency of the issue of a stay on enforcement, ad hoc committees should also have strict timelines to resolve whether to lift or to continue a provisional stay that has been triggered by an annulment application. Third, parties could rely with greater frequency on Rule 41(5) of the ICSID arbitration rules to summarily bring to an end frivolous and facially invalid post-award proceedings. Since its introduction, this mechanism has been used frequently in arbitrations, but very infrequently in annulment cases. This is surprising since a review of an annulment application arguably involves only a review of threshold legal questions and not a review of the merits of the award. It would be, annulment would thus be well suited to Rule 41(5) process, which focuses upon whether the claim is manifestly without legal merit. In conclusion, delays in the resolution of annulment proceedings, underutilization of post-award remedies other than annulment, and ambiguities on the applicable standards governing stays of enforcement have arguably undermined the efficiency of the ICSID system. Maintaining the credibility of the ICSID system requires reforms that will enhance by a combination of using existing tools within the convention, such as other post-award remedies and Rule 41.5, as well as structural reforms, such as award remedies, such as structural improvements to the ICSID rules. Additionally, greater socialization of the rules among decision makers through the development of specific guidance on post-award remedies can help ensure greater compliance with the terms of the ICSID Convention. Thank you.
Thank you, Miriam, for your presentation, and thank you to all of the presenters for their talks, albeit brief. Now is the time for everyone to answer to ask those burning questions that you have arising out of, excuse me, the presentations that we've had, or more generally, the ISDS reform discussions that are ongoing. We have several to start, but again, I encourage all of you to submit your Q&As through, or your questions through the Q&A function at the bottom of your screen. The first question I'm going to direct to Brian, because it relates to or arises out of his presentation. Brian, you suggested that the ISDS reform should take into account WTO treaty practice. Looking further into the future, could a hypothetical global investment court influence WTO practice?
Thanks, Alan. Yeah, cross-referencing in both directions is possible, more so with the benefit of some years for an investment court to build ratifications globally, while building a consistent approach to treaty interpretation across a wide range of investment agreements. The appellate body has, since its inception at the WTO, made clear that it's not to read WTO agreements in clinical isolation from the rest of international law. So at a minimum, yes, parties could raise arguments before the appellate body or the MPIA based on the substantive findings of an international investment court. In that forum, there may be more credibility in citing the elected judges of a global institution than the party-appointed arbitrators of ISDS tribunals. And the most obvious opportunity for this cross-fertilization, I believe, would be in cases interpreting the WTO TRIMS agreement on trade-related investment measures. But of course, as you well know, Alan, UNCITRAL should not be expected to produce a multilateral investment agreement, despite the hopes of some stakeholders. I wouldn't hold out hope for that, as the OECD has attempted in the past. If we have an investment court, the only thing that's certain today is that there will be a treaty establishing the architecture of that court, and predicting anything further than that right now might be putting the proverbial cart before the horse.
Thanks, Brian. Our next question is for Miriam, and it is, given the delays you have described in the ad hoc committees coming to a decision on stays of enforcement, what's the frequency with which such stays are granted?
Thank you, Brian. Thank you, Alan. So as of April 2020, in our review of annulment cases, we found that parties applied for stays of enforcement in 67% of concluded annulment proceedings. So there were about 51 requests for a stay and 40 were granted. In 76% of cases where ad hoc committees granted a continuation of a provisional stay, it was ultimately rejected on annulment. They also ultimately rejected annulment. So there is a downward trend, and ad hoc committees are granting stays of enforcement in fewer cases. In concluded annulment proceedings registered since 2015, applications for stays of enforcement were requested in 15 cases, but were only granted in 7 cases. So it's about 47%. But given the frequency with which ad hoc committees are asked to consider whether to continue a stay of enforcement and the implications of such a request for an award creditor, more guidance on this matter would greatly aid not just stay proceedings before ad hoc committees, but also stay proceedings before domestic courts that are adjudicating the enforcement of awards.
Thank you. I will comment that one of the real areas of criticism that's been expressed at UNCITRAL Working Group 2 is the length of time, which invariably adds to the cost and expense. And it's one of those situations amongst several where the participants are complaining about something that is to a great extent their own doing. They say, oh, everything takes so long and costs so much, but yet rather than seeking to achieve an outcome, a final outcome, as expeditiously as possible, they will do whatever they can to extend and delay the process. So it will be interesting to, I think in particular, whether as a result of the Working Group 3 discussions over the next 5 years now, whether anything is done to limit or restrict the ability of parties to work to run out the clock or ask for stays or extensions and things like that. The next question is from one of the attendees, and it's a more general question. It is, would the establishment of an international commercial arbitration and conciliation center in California, Los Angeles, San Francisco, be viewed by the ADR bar and existing centers as a contribution to or diversion from the development of alternative dispute resolution internationally? I'm going to assume that that comes from someone who is in California and perhaps is looking to establish a new commercial arbitration and conciliation center. And I'll at least give a first shot at an answer to that. And I think the answer is, it probably depends on who you ask. I suspect that the existing arbitral institutions would say there's no need for that. I think that to a great extent, it would depend on how it's viewed by the parties, whether it's viewed as a viable option, perhaps in terms of increasing diversity amongst arbitrators and counsel, increasing the speed, reducing costs, that sort of thing. It's most ISDS cases are before ICSID or the Permanent Court of Arbitration, applying the UNCITRAL model arbitration rules. So whether another institution would be viewed as a contribution or diversion from the development of ADR, I think depends on what it has to offer. Brian, you indicate that you've got some question.
Well, I didn't want Kieran to escape without a question, so I was genuinely curious. I very much enjoyed Miriam's presentation, in particular because it reminded me of the same point that I was discussing about cross-fertilization, the post-award revision mechanisms and interpretation that you're talking about. That comes, as I recall, originally from the International Law Commission's model arbitral rules of procedure. But my question was for Kieran on the exhaustion of local remedies. As I recall, at Working Group 3, there are some states and stakeholders who might like to see something like this, presuming it's within the scope of the outcome. So based on your study of how this has worked or might work under the USMCA, you mentioned this in regard to Mexico. I'm wondering if you think it's a good idea for a non-regional, global-oriented structure. Thank you.
It's a really interesting question, especially when you try to piece together the divergent approaches states might take in different fora. So I'm actually going to jump to Canada to give an example here. So Canada is committed, as I mentioned, to CETA and ISDS through CETA. And on the other hand, in the USMCA, it's withdrawn entirely from ISDS. I think that seems a bit schizophrenic in some ways. Why would you be committed in one forum but no longer be committed in another? And I think the answer that a lot of commentators were looking for came in the new model FIPA, the foreign investment promotion and protection agreement that was released by Canada just about a month ago. And in that agreement, you see that Canada remains committed to ISDS, but only alongside other types of dispute resolution mechanisms. So you see mapped out in that model FIPA that ISDS exists, but it's not going to be the first alternative or the only alternative to resolve disputes with foreign investors. And I think that that is the future of where a lot of, in this ISDS reform debate, that is the future of where states are headed, that they are open to ISDS as a mechanism, but it won't be the first resort or the only resort. Now, what's interesting in the USMCA is that there is a fork in the road provision, and then there is also the, when you have the exhaustion of local remedies requirement being met, it requires that allegations be under Mexican law. And that was what needs to be litigated in the local forum. And in contrast, that you can have the claims under USMCA, but that's when you, for the first time, allege violations of international topics. So it's a contrast from what you must allege in the litigation requirement. And it requires really more in-tuned lawyers. I mean, you need to be getting legal advice both from ISDS practitioners who might represent a company and an ultimate claim there, and then also from your local counsel.
Thank you. You know, one of the things, we're almost out of time here, but I was going to say is one of the great certainties, I think, of the reforms being discussed of ISDS is that there is great uncertainty. The reforms being proposed range from virtually abolishing the current ISDS system for something you know, involving a multinational court to hear investment disputes, to having a multinational court for appeals, to you know, requiring exhaustion of local remedies, as has been discussed. It is a great deal of uncertainty, and the as mentioned, the most recent session of Working Group 3 was devoted entirely to trying to map out the schedule for the next, to address all of the potential reforms. One of them is going to be the creation of an international advisory center on the modeled offer on the WTO's advisory center for developing and near developed countries. And over the next 5 years, the proposal is that the working group will have formal sessions not twice, but 3 times a year, and that there will be a whole number of intersessional informal meetings around the world to address the various topics. Certainly, the reform of the ISDS system is going to not go away anytime soon, and it's going to be, you know, discussed and debated to a great deal over the next 5 years. And at the end of that 5 years, who knows what we're going to have, whether it's some version of USMCA, you know, 5.0, or some version of the WTO, or something in between, or in effect, just some tweaks to what we have now, remains to be seen. With that, it appears that we are at the end of our time, and we've got no pending questions. So I'm going to turn things back to Juliana.
Thank you. On behalf of the Washington Foreign Law Society, thank you to all the panelists for their brief concentration of what we have written orally for the benefit of our attendees. I put the discount code that generously our editor offer, so use it. And thank you all for participating. The recording of the session will be on our website in a few days. Thank you. Bye-bye.